I see the little red light. We are on YouTube. Good morning. This is the Kansas Court of Appeals holding oral argument by Zoom. This is the last of 3 cases on our docket today. Donna Huffman versus Meier Ready Mix and others. Case number 12971. This case has been set for 20 minutes of argument. My name is Gordon Atchison. I will be the presiding judge. I want to introduce the other members of our panel. Judge Kim Schroeder, who joined our court in 2013. Most immediately before that, he was a district court judge in Southwest Kansas for 14 years. Also on the panel today is Judge Sarah Warner, who is the newest member of our court. She joined us last year from private practice in Lawrence. I have just passed my 10th anniversary on the court. Before that, I was in private practice for a long time in the Kansas City area. Could I have the appearances of counsel, please? Ms. Hoffman, you're mute there. There you go.
Yeah, thank you. Of course, Your Honor, this is Donna Huffman on behalf of the appellants.
Okay. And who will be arguing on behalf of the appellees?
James Foland, Your Honor.
Okay.
On behalf of Myers Ready Mix and Lena Mercado.
Do you have a Kansas bar number, or are you relying on Mr. Marakian to be just and proper here?
Mr. Marakian, Your Honor.
All right, very good. I will remind counsel, first of all, that we have read the briefs. We are familiar generally with the facts. Unlike our live oral arguments, this oral argument is being live streamed on YouTube and recorded, so it will be out there for posterity. And Ms. Huffman, you are the appellant. Do you wish to reserve a portion of your 20 minutes for rebuttal, and if so, how much?
I do, Your Honor. Thank you. I wish to reserve 8 minutes.
8 minutes. Okay. Whenever you're ready to proceed, Ms. Huffman.
Thank you, Your Honor. Appellants appreciate oral arguments on this case, and although it is intimately important to, frankly, myself and my family, it's a representative brief of some of societal issues and fully compensating individuals who have been hurt in an accident. I want to make sure that I'm just not waiving any arguments because there are so many good issues. I can't touch on all of them. However,
we treat all of the arguments in the brief as preserved, whether they're reached at oral argument or not. So okay, don't worry about that.
I thought I would start really with one that is of extreme financial importance and frankly seems pretty clear cut from appellant's view. With the admission of liability by the insurance agent in the email, and the fact that the issue was sent to the jury to determine liability despite the vicarious liability of Lenny Sheets. You'll see that email in the appendix. It's actually appendix 2. And one of the large problems was that the judge didn't even have to make a decision on it because in no portion of the record, and either pre-trial when this was made or during trial or post-trial, did the appellees even present a competing affidavit or any indication that an insurance company wasn't going to accept full liability as to the entire case. The only evidence we had was the email and my affidavit on that. So we feel like this is a sufficiency of evidence issue. The judge did indicate that he felt like it was teed up for appeal. And so I would ask the court find that there was no contrary evidence and that we should not have had the admission of liability excluded. I think that that should have been imputed to appellees. And that in this case is about a $200,000 error. So despite feeling that it's pretty clear, I wanted to bring that to the court's attention initially. One of the issues that I think would be most important to this court moving forward for all cases is the statutory issue of the loss of consortium. It was 40 years ago the last time the courts revisited this and did in fact find that it didn't meet constitutional muster. I think that where appellees argue that statutory construction totally misses the mark. I mean, the appellee's brief frankly doesn't hit most of the arguments and seems to try and engage in persuasion, but it's not a statutory construction issue because the purpose of the courts isn't to take every statute as it's written. It's to evaluate whether it meets constitutional muster. And in this case, we have the issue of someone who was in a relationship, but even if not, I think it's Hodges that discusses that we have the right to determine our family and our happiness and our autonomy. So the lack of 90 days of a piece of paper, considering at the trial there had been 8 years of marriage, shouldn't discount any ability to retain damages for that. One of the just most simplistic ways to analyze this is that married people are being treated differently than individuals. And there is absolutely no rational basis for denying an individual in an accident their mileage to a doctor's appointment or the value of a clean house because they weren't married and contracted to give it to their partner. I mean, they deserve it as much as any other individual in the state. And so I think we need to eliminate further the marriage preference, and the court should find that that does not strike as equal protection. And as such, I also would supplement that Judge Rebuttal, although she's federal and it's not binding on this court, I cited some cases because she talked about what about the damage in the future in her cases. And in this case, 90 days after the accident, undoubtedly I was wed, but nobody knew it was going to be permanent. And nobody understood the damages that were going to unfold until we were at this trial quite a ways in the future. Similarly, yeah. Oh, I thought I heard a question. Similarly, I'm really concerned about this issue of tender. I don't see anything from the appellees relating to the Barrett case, and I think it's pretty clear that tender to be effective has to be unconditional. The record has the court order, which was requested by the defendants. The defendants continue to monitor this money. I'm under a court order to advise whether I've taken any money. They wanted to attack the appeal using it. So we're here 9 years later and not a dollar has been distributed. They would say that that's my choice, but my choice under their arguments were that the appeal would be dismissed and it would be considered acquiescence. So I think Barnett is totally missed by the appellees because it is only logical that we all recognize that this wasn't unconditional tender. This tender comes with court orders discussing whether I take any of the money so that they are on notice that they can take further action. And in this case, at one point, they actually moved to dismiss the appeal, which was denied. So I really feel strongly that we need to have appellees acknowledge, or this court find, that if it's an unconditional tender, they can't maintain control of the money. They can't require me as a matter of law and court order to identify if I took the money. And that was always, frankly, the purpose for checking that within a week to 2 weeks, because many people may have taken that money. I myself didn't even order checks. That may have triggered an issue, but I saw that coming. So the money's there. And then now we're still 9 years later. And even though tender's not complete because the court and appellees did not grant the $500 for service, which is a cost, that's still outstanding. Certainly, the interest on the money is unacceptable. It's far less than the judgment rate. And that was something that the judge did to get it out of the court's hands, and was not something that we had a lot of options with. And undoubtedly, I needed to comply with the court. I mean, I think that when you read the transcript, it's clear that the court decided they were going to put the money in the account. I am not so deficient in intellect that I would leave $300,000 sitting in a bank account at less than 0.5%. Although that brings us into one of the next issues: is it full compensation if we reduce the interest as if historically a 9% average, when we all know at this period in time there's actually no interest. I've also asked the court to weigh, frankly, the balance, the idea that a plaintiff doesn't even get an offset of their time. So $78,000 in medicals came with no interest, even though incurred prior to the trial. Then the future medicals come with an automatic reduction of interest. So I understand that our courts have been moving forward on issues of full compensation, but I think this case really illustrates some of the problems with getting full compensation if you are single, if things do take a little bit longer, and frankly, if you're outmatched by an insurance company, because I don't know how anybody affords to get to this place or wait that long. I think there's an inherent problem when somebody has zero compensation for 9 years and has to risk trading the right to appeal against getting those funds. So I'm not sure exactly where I am on my time, Your Honor.
You have about 3 minutes left of your initial time.
Thank you. So I also would like to just prematurely address something I saw in Appley's brief before they discuss it, so that I can bring this up. I do think that the issues that we've selected to bring forward are right under the record that we have. And I think that any argument from Appley's that the entire trial needed to be transcribed rather than as set out in the requested transcript really is a trap for any plaintiff, because 9 days of trial is too expensive. And federal courts allow portions, and our courts expect cooperation in allowing portions. I think it's Rule 3.3. But in this case, Appley's wanted everything. And part of everything even included sections that were very personal and already protected by the judge excluding witnesses, the judge putting a gag order on those records, and they were all supposed to go forward should we have the right to appeal. Now, understanding and weighing, then I asked the court to allow transcripts to be prepared for specific sections. And it appeared that that was ruled favorably, and then it was not. So the choice was we could not get any of the rulings that were outside the jury. And some of those things that I think may have been helpful for other issues. However, I tried to be very careful to bring the court only what was clear from the record. And despite the general argument that plaintiff doesn't have enough to move forward without the full record, that does ignore that we have 7 years of pre-trial record, the motions in limine, extensive rulings, and some post-trial argument. So
Ms. Huffman,
yes.
you are now about to move into your rebuttal time. You're free to use some of it now if you wish, or you can retain all of it. And we'll hear from you.
Your Honor, I'm going to retain all of it. I appreciate your warning on that, and I'll just want to respond to what Applee's saying. Thank you.
Thank you. Mr. Folland, we'll hear from you now.
Please, the court. Let me start with the last point. It appears, or appeared, and still does, from the appellant's brief, that there are a number of things that would require this court to review the entire record to determine whether or not the trial judge erred in some fashion. And certainly if there was an abuse of discretion in any way. While we did discuss at length the transcript, we believed and still believe that there are a number of these points that the court can't adequately resolve without seeing the transcript. The very first one, where she, Ms. Huffman, argues that there was an admission of liability. She cited in her brief a portion of the email from an adjuster by the name of Lenny Sheets, who was dealing with her and attempting to settle the property damage claim on her car. We put the entire thing in evidence in our brief, and it was at issue before Judge Smith in pretrial motions. He heard argument on it and found that there were really 4 different reasons for excluding it. That there was not an admission as to the entire case, that it was settlement negotiation about her car, as reflected in the email itself, that he expected Ms. Huffman to get back to him about the settlement, that it was inadmissible hearsay, and for all of those reasons excluded it initially. However, he left it open and left open for Ms. Huffman and counsel to raise that issue again at trial. They were free to take Mr. Sheets' deposition, free to put on any other evidence that they had, anything about it not being hearsay, not being settlement, not injecting insurance, any of those other issues. And instead, they chose to say at trial, although you can't really tell that because you don't have the transcript on that issue, that they were re-arguing what they had argued before. And Judge Smith, I believe, properly excluded it on that basis. Had there been additional evidence, had there been an additional proffer, he had already told them he would consider it. There wasn't. But again, it's hard to see because that portion of the transcript is not available to you.
Well, let me jump in here before you move on to something else. I want to ask about the post-judgment interest issue and the tender of the judgment amount that was made to the court, and it's now sitting in a bank someplace. Is it your position that if Ms. Huffman removed some or all of that money, it would be an acquiescence in the judgment and defeat her right to appeal?
If you were asking me whether or not, had she removed that money, would we have filed a motion with this court suggesting that the court no longer had jurisdiction because of acquiescence? The answer is yes.
Okay.
Now, I don't know how the court would have ruled on that. We certainly called it to her attention so that she would be well aware of what we intended to do if she took the money, so she wouldn't be surprised.
So how is that an unconditional tender then?
She could take it if she wanted.
Well, at the risk that she would then be acquiescing and lose her appeal. That's a condition.
No, it's not. It's
How's it not a condition?
I don't know whether it was acquiescence or not, Your Honor.
Well, you were going to raise the point, and it could very well be. It would be unconditional if you said, okay, the money is there and we're not going to challenge it as acquiescence. You have access to it. That's unconditional, isn't it?
It is not. My clients don't.
Well, it is. The question is whether what you've done is unconditional.
My clients don't have to give up a legal right based on what the plaintiff does. That's what you're saying. You're saying we would have to give up a legal right. And that's
I understand. You want to cut off the post-judgment interest, though.
Correct.
I mean, you want to have, well, it seems to me you're having it both ways. I mean, you've paid this money into this place where she can't touch it without likely giving up her appeal, but you want to cut off post-judgment interest on it. Is that what the law is?
Yes.
Okay. What authority do you have for that?
All three of the cases we cited, those Bartlett, McGuire, Long, you can pay it into, you can tender it or pay it into court. We paid it into court. It's her choice as to whether she takes it or doesn't take it. My clients don't have to give up any legal right that they have to ask this court to dismiss based on lack of jurisdiction. Whether you do or not, I don't know. But it is a legal right they have that they don't have to give up when they pay that money.
Counsel, I want to ask you a question about liability again.
Sure.
When you filed your answer in this case, I'm assuming that there was a general denial of liability. Is that right?
That is correct.
Okay. Was that discussed at the pretrial conference?
The fact that we were not admitting liability was absolutely discussed, and that we believe that the plaintiff was at fault in the accident, which came out in the evidence, which you don't have that transcript. So.
And where, just so I have it, do you happen to have the site to the pretrial order in the record?
I do not.
That's fine.
Another issue that Ms. Huffman raised was the loss of consortium issue. I believe certainly the trial judge was correct in his ruling. The statute is very clear that it relates only to married persons. There was no common law right, so we're looking at a legislative decision as to who is or isn't covered by that. The Supreme Court has looked at that statute on a number of occasions and has not found it to be either unconstitutional or denial of some kind of equal protection. This particular case is unique because of the parties at the time of the accident, but the statute itself, I think, if someone wants to change it, that's up to the legislature. In the brief,
Counsel, are you aware? There's this discussion about the loss of consortium potential claim for an offspring.
yes,
And are you aware these other states that have recognized that right? Kansas has not to date recognized that right, but these other states that have, is that by way of a statute? Is that by way of a common law recognition? Where does that arise?
I know for a fact that some states have done it by statute. Because of that understanding, I have to assume, and I'm doing that without telling you specifically that I know, that there probably some of them have done it by common law. But there was no common law, initially, was no common law right for a child consortium claim. Kansas has not enacted a statute. It's been rejected by the Kansas courts that have considered it, including the Kansas Supreme Court. But I can't answer your question directly. I believe it is both, but I am not certain.
Thank you.
Ms. Huffman also raised the issue of full compensation. I'm not sure really how to address that, except to say that the instructions on the issue of reduction to present value is part of the approved instructions. Both, again, you don't have the transcript, but I will represent to you that both of the economists, Dr. Baker and Dr. Raju, who testified, did talk about that issue and did put in a formula. So it was part of the evidence. The rest of the issues on full compensation, I'm not, again, without the transcript, it's kind of hard to see, but there was significant testimony about damages from doctors on both sides, from psychiatrists, psychologists, MDs, rehab people, a variety of testimony. And the jury got to weigh that and made their decision on all the categories of loss. And Ms. Huffman was awarded damages, significant damages, frankly.
Counsel, procedurally, what are we as the court to do? You've made some representations about what happened at the trial. Your opposing counsel has made some representations as to what occurred below. Without a trial record, we can't consider any of that, can we?
I don't think you can, no, and I apologize, but it seemed to me I had to address that issue, like the full compensation issue, because I know the case law suggests that there has to be evidence of these things, and I guess I am getting outside of the bounds of what's before the court. I recognize that. I will tell you what is in the record. There was a post-trial motion that Judge Smith heard on March 27 of 2019, and it's page 8 of the reply transcript, I believe, where Donna Huffman is quoted as saying to the court, the plaintiff, my burden to designate, it is my burden to designate the record. If I fail, I can't win at the Court of Appeals. That's her quote. And I believe you're probably correct. I'm probably, neither one of us should probably be saying anything other than there's no transcript to address that issue. And we've done that in our brief, and I think that is correct. For instance, the last issue that I would address is the jury instruction issue. The instruction conference is not before this court because there is no transcript. And I believe it is impossible to make a decision reversing this case on any of those issues, because you do not have anything before you to tell you what Judge Smith heard, didn't hear, whether there was an objection, no objection, no record, acquiescence, agreement, tender by who. It just makes it impossible. And I think the statutes on no record of objection, KSA 60-404, and no record of proffer, KSA 60-405, say that those issues where the record is required simply don't allow this court to consider those issues. And that's all I have.
Okay, thank you. We never punish lawyers for not using all their time.
And I appreciate
that. Ms. Huffman, that said, however, you still have your 8 minutes of rebuttal. So you may unmute yourself and proceed. You're still mute there, Ms. Huffman. We can't hear you.
Okay, I've
All
got
right.
it back.
You have 8 minutes.
Thank you. Just following up on the most recent comments about designating the record, I will tell this court, I understand that the appellant has to designate. That's not a question in my mind. However, I will also reiterate that they talk about portions of the record. They're talking about really discrete portions. And the request for the appellate transcripts that were designated cover everything we're talking about. and I don't think it is or should be the law, that a defendant can be uncooperative and try and get 9 days of hearings at about $5 a page for 25 lines, almost $20,000, so that I could have specific rulings, or so that I could have anything on the instructions. I will note that the instructions are, some of them that I've cited were presented by plaintiffs because they're in the record, and that's in brief. But I hope that the court doesn't set a kind of dangerous slippery slope, because so many people had things that were totally irrelevant to these issues. So that failure to designate, from my perspective, isn't a failure to designate. It's a failure of the appellees to allow this court to have that record. And I did want to talk for a moment about this concept of how we got to that Lenny Sheets was just talking about property damage. It's the defendants that made a motion in limine, and I wasn't counsel. I had counsel, so I can't really speak to why my counsel did or did not do a deposition of Ms. Sheets. And I wouldn't even speculate to this court regarding that. However, what I'm looking at is that this is a motion in limine. It was all before the trial. It wasn't even allowed to be brought up in the trial. And when you are limited from this information, it would seem that it has to be based on evidence. And there is no evidence. It's all speculation and arguments of counsel that that conversation was only relating to property damage. I mean, we talked about bodily injury, and I shouldn't have to convince anyone about it, because frankly, appellees never brought forth any evidence, just argument as to that affidavit. And I just do feel like it's quite a stretch on how one might think they will cover 100% of the property damage, or the email saying we normally do this verbally, but the email then says that they've accepted liability. She confirmed it. It doesn't say 75%. It doesn't say we accept on property damage only. So the only evidence, and it's well established in the record, is frankly my declaration relating to the email. But even if we read the email at face value, we might come to those conclusions, but I think that we're still on clearly erroneous grounds. And I don't think that there's anything about motions in limine that are not preserved when there's transcripts talking about them, because we don't have the actual trial transcripts, because those would have also been covered because they were outside the jury. You know, we talk about this quote that I made, and it is out of context. It is where the judge and I were going over, if you look at the record, what I designated, the portions, because it looked like we were able to do that at some point. But you know, this court was not unsympathetic to some of these issues. I mean, the court had said in volume 14, line 8 to 21, that relating to the law as it is now and maybe what it should be, he said that he understood the issue. I'm not suggesting, in fact, that you, I wish you good luck to set aside, but Kansas is not unique in this respect. We have a lot of square pegs and round holes. We have a lot of legal framework that's dealing with a society that's changed so radically that, think about it, the best example, attorney cases between gay couples using statutes that were specifically designed to chase down deadbeat dads and child support, determining parental rights between gay individuals over children. It's the wrong system. It doesn't make sense. And that's what I say. So Lord knows there's plenty of these areas to be changed. And our society has changed since 40 years ago. And the last time I can find that our Supreme Court dealt with this specific statute, it was found unconstitutional because men weren't covered. And now it's married women and married men are covered. And it's time for it to be all Kansans are covered, because my damages shouldn't relate to whether I had a piece of paper. My damages were relating to this accident with the tortfeasor. And I do think that this is just got to change. And I'm hoping that this case at least move it forward, even if it doesn't help me in total. I find that very important. As to whether child rights, statutory or common law, I think this is common law. We don't see statutes and legislature giving it. You know, Kansas has adopted, I think it's the second restatement of torts. It acknowledges these things. And we have judicial carve-outs, which I'm not being critical about, but this has just been one of them. But 1965, our sitting Kansas Supreme Court said that they acknowledged what loss a child would have. And that anybody would, and I don't want to use the wrong adjective, it's in the brief, but basically not be able to state otherwise. And if we know that that person, the relationship's damaged, why do they even have more preference than a potential husband? I mean, you have your highest duty to minor children. And if you're a single person with minor children, but I don't really want to debate what society has done and whether we think it's right or wrong. Our standard is there one group of individuals that are treated differently? And the answer is yes, it's married individuals. And that PIP instruction was presented in the record by plaintiffs. I do think um, 1965. Oh, I have my brief and I appreciate the oral argument, but I'm very hopeful that this gets remanded and some things can move forward with this case, because it's been a long 9 years.
Thank you. Appreciate the argument of counsel. This is a challenging case. We will take it under advisement and get out an opinion as soon as we can. With that, I will excuse counsel, however you do that by Zoom, and I will adjourn this session of the Court of Appeals. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.